Hey, good morning, everybody. Today we have Matthew Troiani from NVAR, legal counsel up there, who's going to talk to us about a couple of different subjects. The first of which comes down to when we have a ratified contract and it's a conventional financing, no appraisal. And then the buyer's agent calls you and goes, yeah, well, hey, how about if I just want to let you know, we're going to change to VA financing, et cetera. We're also going to talk a little bit about source of funds and how that impacts purchases. So, Matt, take it away.
Thank you again for the invitation and the opportunity, Mark. Would you mind enabling me as a panelist or a co-host, and I'll share my screen? I got some slides to help.
Absolutely. I was just in the process of doing that.
Great. Okay, hopefully that's coming through.
Yep.
Fantastic. Yep. So we will start from the beginning. The good news is that we're aware of the financing issues and, of course, the agency and sub-agency issues, which is why we've been trying to address these through the standard forms. I'm the staff liaison to the NVAR Standard Forms Committee, so if you all have any questions, feedback, comments, please feel free, submit them through the hotline, forward them to Mark or Tom. They know how to find me, and we will make sure that we get those in front of the Standard Forms Committee. I think it is important to note, though, that believe it or not, I'm not just here as some ivory tower lawyer just sitting up here trying to figure out ways to make your lives more difficult. We have a Standard Forms Committee. It's mostly comprised of your fellow realtors, along with a few other attorneys who are affiliates of the association. We meet pretty much every month, plus certain subcommittee meetings. So we're very active, and we're trying to continually make sure that the forms represent the best practices in the marketplace, while also making them a little bit easier to understand. You shouldn't have to have a law degree in order to read these things. Our realtor members should be able to use the forms. They should be clear, concise, not include contractual language or anything like that. Unfortunately, though, there are some things that are inherently educational issues. And the purpose of the form isn't necessarily to educate all of the parties. A contract is to spell out the rights and obligations. It's to create a framework for the agreement. It's not to tell everybody everything that they need to know. And this is where we start getting into some of the important educational opportunities so that you all understand how to use the forms correctly, but also aware that there are certain things that they are not intended to cover. So what are we going to cover here today? We're going to talk about financing contingencies, and we're going to talk about appraisal contingencies. And I keep them separate for a reason. I think that the membership is generally used to thinking of them as being one and the same, but a financing contingency and an appraisal contingency are two separate things. And we'll get into what the implications of that are, especially with respect to if there's a change in financing or if you're using a VA loan program or an FHA loan program. And then in the second part of the series, we'll also talk about agency rules. We'll talk about sub-agency considerations and why we have lots of problems with unauthorized access to property because not everybody is getting those agency and brokerage agreements signed. So if you're able to, as you watch this, I think it's very helpful to follow along. Believe it or not, we actually publish educational versions of all of our forms about a month and a half, 2 months before they go live. So usually in May or June of each year for the July 1 updates, and then November or December each year for the January 1 updates. You can also, we also have a link on the website. I've also included links to the Code of Ethics, so Mark is going to be able to circulate this to all of you, as well as the Century Lock rules, so you have them very convenient and at hand, because they are going to come into play a little bit later. So, financing contingencies generally. A financing contingency really at its core is just a question of at what point does the risk of default shift from a buyer to or from a seller to a buyer if the buyer is not able to get funds necessary to close the transaction. As most fundamental level, that is what a financing contingency is. If there is no financing contingency or any other contingency really, well, that risk is immediately on the buyer. If they don't show up at closing and are not able to get the funds, then they are potentially in default. They could lose their earnest money deposit. They could be sued for damages, whatever the case may be. If there is a financing contingency in place, the question then becomes is how can a buyer exercise it? Meaning how can they void the contract within the terms of the financing contingency? And what, if any, remedies does a seller have if the financing contingency reaches its deadline? So kind of going through the order just conceptually, I think it's important to understand this. Paragraph 2 of the residential sales contract and paragraph 1 of the financing contingency define what constitutes specified financing. It is loan type, the loan amount, it could be a percentage or it could be a dollar value against the overall sales price, the maximum interest rate, and the amortization period, the amount of years it's going to take the buyer to pay off the loan if they decided to go for the full term. Most importantly, I want to be very clear about this. Specified financing does not include a specific lender. It doesn't even matter if the pre-qualification or pre-approval letter is included with an offer. That is a part of the listing agent and the seller doing their due diligence as to whether or not this is a qualified buyer before ratification, but that letter does not become a part of the contract. The buyer can apply to any lender that they want for the specified financing. So I can't stress that enough. We get that question a lot on the hotline. Oh, well, they moved over to this other lender and they got a written rejection letter from that lender, but it wasn't the lender whose letter they provided it prior to ratification. Can they exercise it? And the answer is, if the rejection is for the specified financing, yes, they can. Alternative financing means any change in the terms of the specified financing. So if you switch loan types from conventional to VA or FHA or vice versa, it does not apply to a change in the lender. One of the other things that we wanted to clarify, and this is relatively new, it's from the July 1 forms release. We clarified, there used to be this word, and it was my least favorite word in the entire standard forms library. It said, should buyer pursue alternative financing? Well, what does pursue mean? Does that mean that a buyer can't have a conversation with their loan officer about other loan products that might be available to them? Of course not. I don't think that was our intention at all. Our intention was that if the buyer wishes to exercise the financing contingency by obtaining a rejection letter from the lender, that they had to do so for the original specified financing, the terms of the agreement that they agreed upon with the seller. They don't get to mix that up, but that doesn't mean that they can't have conversations about other things. If a buyer ends up, they start out writing the contract as 80% finance, 20% down, and the lender says, well, hey, I've got a great 90%, 10% loan program. I can save you money on it, whatever the case may be, less money down kind of thing. And the buyer wants to do that, and the buyer shows up to closing and performs. That doesn't matter. They have tender performance. It's none of the seller business. It's only if the buyer tries to get out of the contract by voiding the contract with the financing contingency does that specified financing come into play. So hopefully that part is clear. Other things that we did as a part of the July 1 forms update is we try to continue to make things shorter, clearer, less passive language. I think a contract should generally use active language. It should define a party, buyer, seller, broker, landlord, tenant, whatever the case may be, what they may or may not do or will not do, and then get into the details. We used to have this formulation in the financing contingency that basically made the contract contingent on something a buyer almost never does.
Hey,
Deliver
Matt,
sorry.
Matt, I had to interrupt you. Can we go back? I just, after you said, I started thinking about something. So
Of course.
the alternative financing, like you said, if they go from 20% down to 10% down, that is a change, and that is alternative financing. And so there could end up being a problem with that. But so I guess my question is, what does that mean to our seller?
If settlement is not delayed and the buyer performs, it should not mean anything to the seller. As long as the money is legal tender, validly obtained, and delivered to the settlement agent on time. Let's say that you set up a contract and it was set up with financing, but the buyer's not trying to use the financing contingency to get out of the contract. But for whatever reason, they decide to switch up the loan product. As long as they bring all of the funds sufficient to close on or before the settlement date, there's no default, there's no breach, there's no issue. The only issue only becomes is if the buyer tries to void the contract through the financing contingency. And in that scenario, that's where the terms of the loan, the specified financing becomes important, because you don't want the seller to have to be in a position of having to essentially release an earnest money deposit and release a contract to a buyer who has changed a very material provision to the contract.
And so, and that was my question. So they get approved for instance, they get approved for 80% financing, 20% down, or let's say the other way around, 10% finance, 10% down, 90% financing. And now they want to switch it to 20% down and 80% financing. And now they come back and go, well, I'm not qualified. Here's the rejection letter because I can't do it at 20% down. I can't do it this way. I don't have the funds. So is that an impact?
And that would be ineffective to void the contract. That would not void the contract. They would have to get a written rejection letter for the original 90-10 split in order for it to be effective. Okay. So as I was saying, though, the one of the issues that we had is that it said that the contract is contingent on the buyer delivering a loan commitment letter. Well, I am sure that it happens periodically, but most buyers, you have to hold a gun to their head in order to deliver a loan commitment letter, because that satisfies the financing contingency. They no longer have the protection of it. So yes, Mike. I think you have to unmute yourself. There's a mic in the bottom corner. I'm sorry, I can't hear you. There in the bottom corner, you should see like a little red slash. If you click on that, you should be able to unmute yourself.
Unmute.
There we go.
Can you hear me now?
Perfect.
Okay. So the buyer submitted Eagle Bank submitted a loan commitment letter. I was looking at the VA loan for the expiration of 25 days, and it was a quick closing. So the 25 days was like the day of closing. So it kind of didn't matter. We either make closing or we didn't, But I thought for comfort purposes and professionalism, it was nice to share the content of the loan, just the fact that he got the loan commitment letter with the buyer and the buyer's agent, because saying that things were okay. And I hadn't seen one of those before. And I thought maybe this is new or something. But one of the things in the loan commitment letter that kind of fell on the floor was he took a TSP loan, and TSP failed to get their act together in a timely manner for closing funds. And he had to take a 10 grand loan from his mom to close, and it all worked. Two things to bring up. One was the loan commitment letter, and the other was the terrible performance of TSP to work into getting cash for an active duty Marine Corps officer. I mean, it was just bullshit, but they were overwhelmed and they didn't get the money on time. And then he finally had to cancel the residential loan and go for a personal loan because he took the money from his mom.
And sometimes that causes problems with some lenders because the funds aren't seasoned. They may have certain underwriting tolerances where they can allow like a gift or a loan up to a certain amount, but
the loan officer kind of looked at the Marine's overall budget and knew he had enough in his checking account to cover the 10 grand, although he'd eat peanuts for a few weeks. But and I talked to the loan officer, but he got the money from his mom and didn't have to eat peanuts, and we closed the thing. But the TSP people, boy oh boy, there's a caution flag there.
I think that really does track. If you're going to be getting funds from any other source beyond like kind of traditional lenders, even if you're borrowing against a retirement account, TSP, 401k, a brokerage account that you have, you can do that, but you have to build in time because none of them are fast. I would say TSP is probably on the slower end, just based off.
It really was. It was to the end of collapse. It didn't happen. So I just share that.
The other issue that we are seeing there that you kind of highlighted is, there's nothing inherently wrong. If the buyer can get to closing, there's nothing wrong with delivering a loan commitment letter. The question though becomes is that what if they needed to hold back at least some kind of out just in case the stuff hit the fan. And if the loan commitment letter has been delivered, then the financing contingency is satisfied. The buyer no longer has a protection of a financing contingency. They can't void if the loan gets rejected for whatever reason after that commitment has been delivered.
Yeah, I think
the other issue that we have is that we've seen some buyers' lenders taking it upon themselves to deliver it to the other side, which I have a problem with.
I didn't deliver the letter as such. I just delivered the fact that the letter had been received by the buyer, because it still has.
And that's okay. I mean, as long as you're not delivering the actual commitment, you're not removing the contingency. I'm just talking about what we've heard in the marketplace is sometimes the listing agent is like burning up the loan officer's phone or email, and then the listing agent then the loan officer decides, hey, we've got a commitment letter. I want this person to stop calling me. I'm just going to deliver it and get them off my case. And then the buyer's like, hold on a second. I didn't authorize you to send that. The contract says that the buyer delivers the loan commitment letter, I think, not the lender.
My saving grace was the loan officer had looked at the finances, the funds available for closing that the Marine had in other areas, and he knew there was enough to scrounge up even if the TSP loan fails. So anyway, okay, sounds good.
All right. So what we've tried to do here with the changes to the forms is to just say, look, there is a financing deadline. And then depending on what type of financing contingency you have, there is a different impact at what happens at that deadline. If you have the financing contingency, that's kind of the more traditional one. We call it financing contingency with automatic extension. What that means is that the contingency and the protection of the contingency continues after the deadline. But any time after the deadline, the seller has the option, they're not required to, but they have the option to deliver a notice to the buyer that says, you have 3 days to void or this contingency is removed. Now, I can understand that is, from a seller's perspective, probably not the most satisfactory remedy, because essentially you're giving the buyer a get out of jail free card. If they deliver that notice, the buyer can void for any reason or no reason whatsoever within those 3 days. So I understand why some sellers would be hesitant about it. But we've gone round and round and round on this on the Standard Forms Committee. And as far as we know, this is the best formulation that we can come up with for this, because there's no way that we could mandate that a third party, not a party to the contract, like a lender, could be able to produce a rejection letter within 3 days. And we can't compel them to do that. So we've given this option, but it's not, it's not 100%. We understand that, but we have not been able to come up with a better formulation, except we now give the parties options. Now, of course, we released this second version of the financing contingency with automatic expiration right before the pandemic happened. And up until about 2 months ago, I have not seen very many financing contingencies in contracts. So maybe it was just, not the best timing in the world. So I don't know how much of the membership is aware of it, because they haven't had contracts with financing contingencies for a while, but they do appear to be coming back. But you do have options now. The financing contingency with automatic expiration just says the buyer can void by delivering a rejection letter anytime up until the contingency expires. And then after that, the risk of default is on the buyer and the contingency is removed. And of course, we also clarified that at any time, if the buyer does deliver the loan commitment, they satisfy the contingency and then it's done. Or if they deliver a rejection letter prior to expiration or removal of the contingency, contract's void. So try to continue to make that clearer. Hopefully you all also noticed this isn't directly related to the financing contingencies, but it is relevant. We've gotten rid of the initials at the bottoms of the forms. We're trying to make your all's lives easier to get to ratification. I think that the initials were well intended, particularly thinking back to a time when contracts were printed out and you had people filling them out. It's easier to demonstrate that they've agreed to the terms on the page if they've initialed at the bottom. But the vast majority of transactions are handled electronically these days. And in an electronic document, you can demonstrate that this is the parcel that was sent to the party. They signed it. The presumption as a matter of law is if you've signed a document, you've read and agreed to it. And if you didn't, that's on you. So we felt that the initials were not necessary, and we kept getting tickets on the hotline of people getting tripped up. All right, we've got an 18-page contract and we've had everybody initial on every page, but one buyer missed an initial on page 7. Are we ratified? Well, yes, you're ratified. Now, maybe there's a question as to whether all of the material terms on page 7 have been agreed to, but you're ratified. So we just wanted to remove one pain point towards ratification. And really, the reality was it wasn't providing any additional protection. Along with that, as it pertains to the financing contingencies, rather than having those hash marks and initials next to whichever type of contingency you're selecting there, we just have a checkbox now. So you can just identify, boom, I've checked this box. This is what applies. We don't need those initials. I still would recommend using the hash marks and initials anytime you've done like a strike through, just to clarify the party's intent and understanding. If you've crossed something out or written over something, you should probably do the initials then, but generally speaking, initials are not necessary on the contracts. Okay. Now, appraisal contingencies, and I address these separately for a very important reason. It is possible to have an appraisal contingency without a financing contingency. An appraisal contingency merely says that the risk of default shifts from the seller to the buyer if the property does not meet the lender's appraisal standards for the loan. But it has nothing to do with the other buyer's qualifications to get the loan. It doesn't have anything to do with their employment, their income, their debt to income ratio, their credit score, nothing like that. It purely is tied to the value of the collateral. So you can have an appraisal contingency without a financing contingency. I would argue, however, that it is almost impossible to have a financing contingency without at least an implied appraisal contingency, because a lender can always reject a loan for insufficient collateral. So we've heard a little bit of like people, maybe there's some misunderstanding or people are deliberately playing games out there about like trying to present an offer where like, well, we've got financing contingency, but we'll waive appraisal. That's probably not going to work. If you've got a financing contingency, you at least have an implied appraisal contingency. So we've tried to continue to make that clearer too. Here's the deadline. Here's what the parties can do up until the deadline. Here's what happens after the deadline. We are hearing that the Standard Forms Committee has heard that there is a need out there, and maybe with the market shift a little bit, this might not be as necessary, but we still have some, I think, some pretty good language that we could put out there as a template or a clause to address appraisal gap guarantees. You know, the idea that in the event of low appraisal, buyer is going to pay up to X amount of dollars. And so that would we would build that into as additional language into the appraisal contingency, that the buyer can only seek to void if the appraised value of the property is less the appraised value plus whatever the gap guarantee is, $5,000, $10,000, whatever the case may be. So we are working on that, but you know, by and large, I think we're not substantively changing these contingencies. We're just trying to make them clearer, more direct, easier to use and understand. But that brings us to special considerations for FHA and VA appraisals. And this is tied very closely to what Mark led off with. And he and I have had a conversation about this, probably more than one. And I know, shout out to Mark for being invited to have a conversation with NAR President Leslie Ruda Smith about like VA loan programs and stuff like that. That was really cool. So this is the fact pattern. You have a contract that is either contingent on conventional financing or no financing contingency at all. And then, you know, a week, 2 weeks into the contract, suddenly the listing agent gets a request for an appointment from like a VA or FHA appraiser. And the listing agent's like, wait, hold on a second. What the heck? We agreed to conventional or no financing or appraisal contingency. What's going on here? And that can cause a problem because, and this is where it's an education issue, not a contract issue. Federal law supersedes anything that we can put in the contract. And federal law, if any of you have read the VA loan notice of value or the FHA amendatory clause, says, notwithstanding any other provision of this contract, In the event that the appraised value of the property is less than the sales price, the buyer cannot suffer any penalty, such as forfeiture of earnest money deposit, or be forced to go to closing in the event that the sales price or the appraised value is less than the sales price, notwithstanding any other provision of the contract. Now, well, then you might say, well, yes, but my sellers never agreed to this. We didn't sign a VA notice of value. We didn't sign an FHA mandatory clause because we didn't agree to a VA or FHA financing or appraisal contingency. The problem here is that federal law says that it probably doesn't matter. And we try not to draw too much attention to this because I don't want to encourage any parties to negotiate in bad faith. But on the same token, we definitely have seen an uptick in the last couple of years of the market not being very favorable for VA and FHA borrowers, that there is at least a stigma or a belief that cash or conventional is superior. And so it makes it harder and harder for buyers to get their offers accepted if they've got, if they're, even if they're not making it contingent, but like if they're just checking that they have VA or FHA as the loan type. And so what do? They write it as a conventional offer, they write it as a cash offer, or whatever the case may be, and then they switch to VA. And if the appraisal comes in low, they exercise the VA notice of value or the FHA mandatory clause, and they void the contract. Usually the way that this comes up is if it's not signed at ratification, the listing agent is finding out about having signed the VA notice of value at the same time as the appraiser is scheduling the appraisal. They're going to add, the lender is going to ask that the parties sign the notice of value then and there. Now, technically, the federal law does not require that. The VA and FHA underwriting guidelines say that the notice of value or the amendatory clause have to be signed at or before settlement. So a seller could theoretically hold off signing that notice of value, hoping that the appraisal comes in. If it doesn't, maybe trying to work something out. But the bottom line is that they're probably going to ultimately have to sign the notice of value anyway at closing. Hopefully at closing, it's no longer an issue. Yes, Tom.
Okay, did I miss something earlier? Does this not significantly change the financing? That
It does.
So basically, you've got to tell those folks you're changing to VA, don't you?
I think that somebody could make a compelling case for a potential ethics violation for failure to disclose if the buyer's agent has actual knowledge that the buyer's agent or that the buyer's doing this and the seller and listing agent haven't been informed. But that is different than a breach of contract issue.
Okay.
And the problem that we have here is that federal law says that this is a right that the borrower has. Now, I think it's very, very clear that the buyer is going to lose the protection of any financing contingency because they've changed from the specified financing. They're now in alternative financing. They have a different loan type. But remember, appraisal and financing are separate. And right. Basically the law just automatically provides that if somebody is using a VA loan program or an FHA loan program, regardless of what's written in the contract, they have the ability, they basically have an appraisal contingency.
So basically, if I'm a listing agent and I get that change from conventional to VA, I basically can say, fine, we will do that, but you are removing the financing contingency.
Yes.
Okay.
So their EMD would still be at risk if they didn't qualify for the loan. The only issue is just going to be whether or not the property appraises.
Okay. Thank you.
Of course. Now, one of the things that I like to remind people of this is that, look, the notice of value says notwithstanding any other provision of the contract, but people write stuff in all the time, right? You could have somebody with a VA loan that writes in an appraisal gap guarantee. Well, under the VA notice of value, that would technically be unenforceable as well. Because remember, notwithstanding any other provision of the contract, we've got if the appraised value is low, they can get out. And I think that all the people on this call by and large can attest to this. Our service members are among our most honorable people in our society. Whether or not it's strictly enforceable is a matter of contract. If they say they're going to do something, they're going to do it. There's what the contract says, but then there's what the parties end up doing and performing. So generally speaking, I think it's going to go through. We all know that, it's still a low inventory market. Buyers, if they find the property that they want, they're going to go, they're going to go through whatever they can in order to try to actually get that closed, particularly if they're on like a change of duty station or something like that, where, the clock is running too. They got to get their families settled. So, but I do want to just, drive awareness around this, that, regardless of whether the parties have agreed to the relevant contingency, if you got a veteran using the VA loan program, they're going to have at least an implied appraisal contingency. And I have a really hard time believing that there is a single judge in the Commonwealth of Virginia that's going to find that a veteran didn't earn that benefit.
So
and find against the veteran.
So Matt, whether it's VA or FHA, the fact anecdotally, if somebody comes in $60,000 over list price, waiving the appraisal conventional with an appraisal gap addendum, and then switches to, let's say, FHA, then the appraisal got the appraisal, now they have to have an appraisal, and the gap addendum is worthless. If they want to say, well, nope, I'm sorry, it's FHA, it's got to go this way. Is that correct?
If they decide that they don't want to bring that additional money, yes, they could. They could probably walk away. You'd have, until I have a judge that tells me otherwise, that's my best analysis. I think that, at least just, and this has very little to do with the law. This has more to do with just perception in the way, because judges are human beings as well, is that I think that a judge would probably treat a veteran a little bit more sympathetically than a VA borrower trying to pull the same thing. But at the end of the day, the federal law basically establishes the same standard for both. And this could be a good time then to touch a little bit on the source of funds issue, because source of funds, I would argue, the way that the statute was written, for those of you who are not aware, back in July 1 of 2020, a lot of people missed it because it was at the height of the pandemic, but the Virginia legislature added several new protected classes under the Fair Housing Statute. They added sexual orientation and gender identity, which are not new. Those are already in the Realtor Code of Ethics anyway, but they were added as a matter of state law. But they also added in source of funds and military status. Originally, it was veteran status, and nobody knew what that meant, so they clarified its military status. And it just simply said that parties cannot discriminate against people on either of those protected classes in trying to procure housing. Now, the interesting thing is about 8 months later, the Virginia Real Estate Board and the Fair Housing Board published a guidance document that essentially said, even though it's not specifically stated in the Virginia Code, but they interpret this as only applying in the rental context, basically, that it is not considered discrimination against somebody on the basis of source of funds or veteran status for a seller to reject an offer from a buyer using VA or FHA financing. Yes, Mark.
So initially my understanding was that this actually fell under Virginia Residential Landlord Tenant Act. It does not. It encompasses all rentals, then, is what you're saying.
It does not encompass all rentals. It is actually specifically tied to the number of properties a landlord has. Our government affairs teams at the state and local level really kicked in and carved out some pretty significant exclusions. It's one of the only areas where you have a significant exclusion under the Fair Housing Statute either. As it pertains to source of funds, it only applies to leases, residential leases related to landlords who have more than 4 rental dwelling units that they lease in the Commonwealth of Virginia. So if you have a mom and pop landlord that's got 4 or fewer properties, or a 10% ownership interest in 4 or fewer properties, then source of funds doesn't apply to them regardless. They do not have to accept housing choice vouchers, anything like that. And it does not, just by virtue of the fact that they work with a real estate licensee, does not automatically tie them in either. They specifically did not include that source of funds piece under the section of the Virginia Fair Housing Law that pertains to real estate licensees. So basically the biggest takeaway here is that unless you are a landlord who has more than 4 properties that you rent out in Virginia, and regardless of how many properties you are selling, you probably don't really have to worry about source of funds.
And so source of funds, whether it be housing voucher, which I know people don't understand, you can buy a house with housing voucher,
Mhm.
okay, or VA or FHA. So can somebody deny an offer or a purchase based on source of funds?
Yes. The VREB and the Fair Housing Board guidance specifically says it is not discrimination for a seller to reject an offer from a buyer using VA or FHA loan. So, which to my mind kind of blows a giant hole in the in that, but you know, that's how they've interpreted it, and I think it's easier to understand as well. It would be, you know, to suddenly make sellers have to consider all different sources of funds and things like that, I think would cause a much more significant problem in the sales market than it does in the rental market. Okay. So I can pause here because I'm ready to go into sub-agency, but I'm also happy to address any other questions that you all have about financing and appraisal, VA and FHA.
Yeah, let's go ahead. Anybody have any questions about what Matt's covered so far?
Yes, Mike. Sorry, Tom, I think I saw Mike's hand first.
In today's market and the transaction I just had, so I had the VA buyer, and we knew that, you know, the VA loan required an appraisal. Well, to say that the market's settling a bit, the realtors on the on the selling side said to me, Duffy, it's okay, calm down, because we're going to get this place appraised for a VA appraiser. And it was in Belmont Bay. They made their case, and they helped the buyer get the appraisal, and we got the house. And it was just, you know, that wouldn't have happened a year ago in the market, but it happened 3 weeks ago. And wow, it was neat. It was real neat.
Well, that's fantastic to hear, because one of the things that I've been advocating for a really long time is that just because you get to treat the buyers and the buyers agents like dirt doesn't mean you should. You know, let's try to be human here. At the end of the day, you've got a buyer who wants to buy a property, you got a seller who wants to sell a property. You're 95% of the way there. Let's not overcomplicate this and get this tripped up by egos or trying to demonstrate value. Mark can attest to the fact that before I came to NVAR, I actually did settlements for years. And, you know, we'd have these transactions where the agents are duking it out. I'm basically playing mediator for like weeks up until closing. We got the closing scheduled, and I'm thinking that we're going to have to keep the sellers and the buyers in different rooms. This will definitely date me because this is back when we actually had settlements where the parties were there at the same time. But, you know, I'm thinking that this is going to be a problem. And then I walk up, the buyers and the sellers are in the lobby chit-chatting, having a great time. It was the agents that were causing the friction. So let's not do that. Let's focus on what your client's interests are and let them make that informed decision. And you know what? A lot of the time, given the opportunity, people are going to take the human angle. You know, they're going to be decent. Yes, it may also be in their self-interest to try to make sure that that VA appraisal went through. But particularly in our area, we have a lot of service members. We have a lot of people who are family of service members. They want to do right by one another. And as long as, you know, it's not, you know, too huge of an inconvenience or problem for them, they're going to figure out a way to get through it. And that's just really gratifying to hear. And I'm glad that you shared that, because it's a great example of what we're trying to preach here is, look, you're not going to hear this but from, you know, every lawyer, but don't do that. You know, just because you can doesn't mean you should.
Hey, Tom, you had a question?
Yeah. Matt, I'm in the process of a client is buying a piece of property that's contiguous to her farm. They they went and got applied for a loan, and it was rejected. Okay, the loan was rejected. They said, okay, we're pulling in our partners and we're putting in a cash offer. I've already told the other agent, showed them the receipts or showed them their account balances where they've taken money out of their TSP accounts and stuff like that. So we're like $13,000 short. Their partner would have had the money, but he got COVID 2 weeks ago. So I've contacted the agent. I've told them everything that's been going on, keeping them up front. What paperwork should I submit?
Are you using the NVAR
Oh, yes, sir.
sales contract for unimproved land?
Yes.
I think that the most important thing is to just keep the settlement date alive, because we
Yep.
have the times of the essence clause on that. So,
Yep.
if the seller's amenable to it, kick the settlement date out a little bit longer, give yourself a little bit more time.
The settlement date's August 18th.
Oh, okay.
They plan on having the money by the 1st. So.
Yeah, I mean, the bottom line is that at this point, unless the buyer had some kind of financing contingency that they wanted to exercise, just keeping the parties abreast of what's going on. I don't think that it's strictly contractually required, but I think that just as a matter of ethics and a matter of representing the client's interests to make sure that the deal still stays together, it's a good thing to do to keep people apprised of the progress. But the bottom line is that the buyer is going to show up with the funds or not on or before the settlement date. And that's kind of when you're going to know. It's just better from a seller and listing agent's perspective that they're aware that these things are kind of happening behind the scenes rather than finding out at the last minute, like, wait a second, the funds coming from 8 different sources and what's happening? Why are all these people, involved? At least that way they're not just blindsided by it, which sometimes gives people pause even when they think the transaction's going through. And that's not a happy experience the day before settlement or day of settlement.
All right, then I'm just going to continue on continuing.
Great.
Any other questions? Hey, Jim Evans, thanks for attending. Glad to have you here.
Thanks for joining us today, Jim. Mark, do you want me to give it a pause here, or will you be able to split up the video before we kick into the agency, sub-agency section?
Yeah, give me 2 seconds here. We'll give it a little bit of a pause.